Hello to all. This is D. Satyanarayana again from Abhaya Hastham Foundations Center for Legal Aid and Education. This video is a continuation on the topic Why Study Law from our last session. In the last video, we discussed certain points as to what happens when a student, after completing his schooling, either his schooling or his 3-year undergraduate degree, and takes his proposal to his parents, his or her parents, about enrolling himself or herself into a law degree, and what the expectations as parents they have from their children's legal education. Now the question is, when it comes to law education, one of the motivations, or in other words, earlier motivations students had or the parents had, was that independence of work. For example, as a lawyer, I will not be having an employer who would pay me a monthly salary, right? Because in the last video we have already discussed that we should not be having any stable income or expectations on a monthly basis from our employer. Now, if you are an employee to an employer, there are some restrictions or limitations for your personal and professional growth. But when it comes to legal education and then your profession as a lawyer in the society, sky is the limit. There is going to be no limitations as such. The more you earn is directly proportional to the more you learn. So this is the independence you have as a lawyer in the society. And of course, we can always say that being an advocate or a lawyer is a noble profession. That is going to be a bonus for us. Now, imagine you cross the age 68 years or 58 years. So we have retirement age, right, for a regular employee. Will it apply to a lawyer? No, it does not. In a conversation between one of the leading luminaries of India, Ramjit Malani, who is no more, late Mr. Ramjit Malani, there was a conversation between a judge and him, where the judge asked Sri Ramjit Malani, "Sir, when are you going to retire?" And Mr. Ramjit Malani's response to the judge was, "My lord, are you asking me to die?" What he meant was, Ramjit Malani will practice the law until his last breath. That is what he meant. Meaning, there is going to be no restrictions. I can practice law until my last breath. If I decide, I can stop practicing the law. This may or may not be possible elsewhere. Beyond the financial security or financial income as such, in other words, being a lawyer is, the profession of the lawyer is highly satisfactory. Earlier, it used to be that once a student completes his law degree, he is expected to work as a junior with a senior advocate. But it is not a situation anymore. The moment you complete your law degree and you enroll yourself in bar council of a particular state, you are eligible to practice as a lawyer across the courts in that state and also in front of the High Court of that particular state. This opens huge options for you to focus as to in which area you want to practice. For example, if you are from Chennai and you want to practice in a different city within a particular state, you can very well move into that place and you can start practicing law in that area. And even if you want to move across the state, meaning if you are from Tamil Nadu and let's say you want to practice elsewhere, you can still transfer your membership to another state's bar council and start practicing within that state, including that state's high court. The other reason why I call this as a great opportunity is because right after the completion of your degree, you are independent. You are neither controlled by your seniors, you are neither controlled by your employee as such. What you have learned throughout your education in the law college or a law university, etc., you can straight away apply your knowledge and provide results to your clients who approach you for a remedy. And compared to all other disciplines or all other professions, I would say this is the greatest independence anyone can ever hope for, and it is available for the profession of lawyer. Now the question is, who is best opted for studying the law degree? In my opinion, technically speaking, whatever I am saying in all these sessions is indeed my personal opinion, because there may be other views on a given topic or on a given subject. Everybody can have their own opinions. But in this case, in my opinion, people who love reading, people who have analytical thinking naturally, are really best opted to study law. Because if you do not love reading, merely obtaining a law degree after going through 3 years or 5 years of education in the law school, it's not going to be enough. In a worst case scenario, even if you complete your law degree and you have your law degree at hand and you have your enrollment certificate, and you do not have tendency to spend long hours in reading judgments, in reading bar acts, in reading briefs, etc., it is really tough, for you to continue to practice as a lawyer. Hence, the requirement is you must love reading. Even if you do not have that habit, you must cultivate one. That is an important requirement. Now, let's move on to the next stage. For a moment, imagine the Constituent Assembly, meaning the framers of our Indian Constitution. Imagine if they were not lawyers, right? They were not legal luminaries. Do you think we could have had this brilliant Indian Constitution? It's not possible. Hence, lawyers' role in a society or in building the foundations of any given country is, very much, or in other words, is indeed instrumental. Without lawyers, a nation cannot function. Without law, a nation cannot function. Okay, now you have enrolled as a law student, be it a 3-year or 5-year course. Whenever my discussion or my points would be, in general, it will apply to both the students, meaning students who have enrolled in 3-year law course and also to 5-year law course. There is no specific advice as such for different advices for different students. So this advice applies in general to students who are enrolled in both these courses, 5-year and 3-year law degrees. Now that you have enrolled, the first requirement is that you should read the bar acts extensively. What do I call as bar acts? Bar acts are nothing but the actual laws that are passed by Indian Parliament and state legislatures. If you do not read bar acts, you will never get a hold on a particular subject in law. The drawback in the earlier stages, meaning in the past years, let's say 2 or 3 decades ago, before the advent of the internet, it is the expectation from everybody that lawyer must memorize and retain the sections and other relevant concepts in his mind at all times. It also used to be in practice where lawyers used to carry pocket guides of particular bar acts all the time at hand, so that if they require, they would go ahead and refer the sections and then any other related requirements. But with the advent of internet and other allied technologies, there is no necessity for a lawyer to memorize sections and concepts. But one must extensively read the bar acts and understand the fundamental concepts of all the subjects in law. Without that, there is no way we can successfully practice law once we are done with our education. During your study at law, you must also form, a reading clubs among your friends within your class or within your sections. You must form reading clubs, meaning, five-member teams. Let's say a team of five people come together, decide on a topic, and read it extensively for a week or 10 days. And once in 2 weeks, you must come together and have a discussion for an hour or two on the topics you have read. When you do this as a habit for the whole 5 or 3 years, imagine the amount of understanding you will get on a given subject. Now, in premier institutes, in premier legal institutions, this is done as a practice, but it is not done across all the universities, right? Teacher comes, they use the chalk and talk method, and then in the blackboard they explain the topics mechanically, and then they leave. That particular period is over, and then the next paper is taken by another professor or a teacher. But as a student who is trying to succeed in the law profession, as a student where you have a vision to do something meaningful with your law degree, you must not just rely on these lectures that are conducted through a blackboard. You must move beyond that. You must take extra care. You must work hard. In addition to the knowledge that the teachers are trying to impart through the blackboard, you must take it upon yourself to read barracks, to read the law, and go to your teachers with your doubts. And by this way, if you continue this practice for years together, imagine the amount of understanding you will get on the subject. Now, you are right in the middle of your law course, and you've been studying the barracks thoroughly, and then you're following the lectures very closely, and you're going back to your teachers with relevant questions, and you're getting your doubts clarified in the subject, you're making notes, etc. What you should do right now at this point, that is, you are in midway of your law degree, right? I mean, if you are in a 5-year law degree, let's say you have just completed 3 years, or if you are in a 3-year law degree, you have just completed your 3 semesters and you're stepping into 4th semester. This is the time for you to select a specialization so that based on that subject, you can call yourself as a specialist. For example, if you are interested in criminal law, you must focus on subjects specific to criminal law, meaning IPC, CRPC, evidence, and any other specialized acts that are passed to deal with criminal acts. For example, POCSO in this case. And if you want to focus on civil side practice, likewise you must master procedure code for civil practice, meaning civil procedure code, and any other allied civil laws. It can be anything from Partnership Act to the laws to the company laws to any other act that is not criminal. Now, why should we do this? Because to claim that you are an expert on a particular field, you must have a depth on the subject. Breadth is definitely required as a lawyer, but if you do not have a depth on a given subject, you cannot claim to be a master on a particular subject. We might have heard that we have insurance lawyers, we have company lawyers, and then we have criminal lawyers, we have civil lawyers, right? And then we have lawyers who only deal with admiralty cases, and then we have lawyers who specialize only in competition cases, right? So why do they call that? We have family lawyers, etc. So why do they call themselves, along with this specialization? Let's say we have a family lawyer. Why do you think he calls himself as a family lawyer? The understanding is that he must have spent a lot of time reading and practicing the law, the family laws, and then seeking clients who have issues in the related domain. And then he must have been giving the required remedies to the clients who are approaching him. And thoroughly focusing on a particular subject for a very long time makes you a master in that subject. This is not to say that you should ignore all other subjects in the legal domain. For example, in my opinion, if you do not understand Indian Constitution, if you do not understand the fundamentals of the various provisions of Indian Constitution, for example, Part 3, I would say, you cannot practice any subject in law, right? If you don't understand Constitution, you will not be able to successfully practice criminal law. If you do not understand the fundamentals of Constitution, you will not be able to practice either civil or any other specialization. So, when I'm saying you must specialize on a particular subject, it cannot be at the cost of other allied matters, right? There is this practice in many universities where the institution they will conduct moot court competitions once in a year or twice in a year for students who are halfway through their degrees. At times, these moot court competitions are conducted by external agencies, and it is a practice that many students who are interested in real-time work as a lawyer, meaning who are intending to practice in front of courts, in front of different courts, they will participate in this moot court to gain a real-time experience. My suggestion is that one should not wait for the institution to organize moot court competition or wait for any external agency to publish an invite to join their own competition. Within the university or within the law college, students must form a student committee and under the guidance of an expert, be it an outside expert or a teacher within your college, you must frequently conduct moot court competitions in a year, right? At least once in 3 months, so that this experience you gain under the guidance of an expert by arguing your own cases in moot court competitions or moot court practice, I would say, rather than calling it as a moot court competition, we must label it as moot court practice. So the experience you gain in this virtual training exercise is enormous, because the guide who guides you, being an expert, he will correct you in terms of your approach in procedural law and also the substantial law. Once you are out of college, once you are in the profession, this experience will come in handy to provide best quality legal service to your clients. With this, we conclude today's session. We have discussed so far as to why we should study law and what a student should be doing once he is enrolled into a law college or a university to study law. In the next video, we will be discussing about specialization, meaning we will discuss more in detail about picking up a particular specialization to practice in real time. Thank you.